anything to do before the Honorable, the Justices of the Appeals Court, now sitting at law within the end for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the March 13th, 2023 sitting of the Massachusetts Appeals Court. Let me introduce our panel. Sitting to my right, Justice Kenneth Desmond. To my left, Justice Paul Smith, and I'm Justice Eric Nyman. Appeals Court rules provide that each side will have 15 minutes to make your argument. There is no rebuttal in the Appeals Court. I can assure all of the parties and attorneys that the panel is well-versed on the facts and the background of each case, so we would urge you to cut to the heart of your argument and use your 15 minutes as wisely as possible. With that said, we will call the first case on the list, docket 2022 P142, Pitts versus Director of the Department of Unemployment Assistance. We will hear first from the appellant, Mr. Pitts. Actually, Mr. Pitts, if you would move over to the podium, please, so the microphone can pick you up.
Good morning. My name is Kenneth Pitts. I am the appellant in this case. This morning I respectfully ask this appellate court to consider the violation of GLC 151A47 committed by the employing unit Massage Envy of Brookline. If the Department of Unemployment Assistance and the Board of Review had acknowledged the violation, it would have altered the course of their action, which disqualified my eligibility for benefits. The appellate court has the authority to review the violations and reverse the decision of the DUA Board of Review and lower court, that is Brighton District Court. In March of 2020, our clinic was shut down due to the COVID-19 pandemic. On May 15th, a Zoom meeting was had clinic-wide to discuss reopening and safety issues such as linen reuse, etc. In June of 2020, the 12th, I spoke with Lauren Ben and Andy Kwan, management and ownership at Massage Envy Brookline, by phone regarding safety concerns, etc., before signing a return from furlough document. At that time, I was told that Massage Envy Corporate was designing a protocol that would allow the reuse of blankets during the COVID pandemic, which was a violation of CDC and Massachusetts state reopening guidelines. On July 1st, another clinic-wide Zoom meeting was had, and the Massage Envy protocol was announced to and required for therapists to use. The following day, I met with Lauren Ben and Andy Kwan again regarding safety concerns surrounding the blanket reuse protocol.
When you say regarding safety concerns,
these
yes, were
sir.
safety concerns that you had?
That I had, as well as the other therapists.
But you weren't representing the other therapists, right? You were only speaking for yourself.
Actually, the information, the transcripts will show that other therapists actually had concerns as well.
That may be true, but you weren't speaking for them. You weren't representing them, right?
Oh, no, I could not. I could only represent myself.
So we're talking about the safety concerns that you had.
Yes.
Okay.
But see, safety concerns were expressed by other therapists in the previous Zoom meetings, and then later on, they were expressed to those individuals.
Got it.
Yes, sir.
And at that point, had you signed the return to work document yet?
Yes, sir, I had. I had planned to return as long as I would not be required to reuse blankets with my clients.
Okay, but that document doesn't say anything about as long as, right?
Actually, it does. I actually highlighted.
Oh, that's what you wrote in there?
Wrote
on
in
that
some
document?
notes there.
Got it.
Yes, sir.
Okay.
Yes, sir.
Go ahead.
Excuse me. So I met with them again on July 2nd, and I was told at the end of the meeting, because of expressing my lack of comfort with reusing the blankets, to return when comfortable doing so, and that can be found in the transcripts as well. On July 16th, I received a phone call from Lauren Ben telling me that I should return to the clinic as quickly as I could because clients were waiting on me and the clinic was losing money because of my delayed return. She also expressed a work share program.
May I interrupt you? I'm sorry, Mr. Pitts.
Yes.
The hearing examiner made a finding that the employer chose to change blankets after every session. What do we do about that?
So the employer said that that's what they were going to do. They made it a requirement that all therapists would need to follow the protocol that was designed by corporate.
Well, but the hearing examiner, at least my understanding, is that they made a finding that there was a protocol, but that they could go beyond the protocol as well.
Yes.
And again, there is a finding that the employer chose to change blankets, did indeed do so after every session. I
Sure.
think you're stating that's incorrect and that's fraudulent.
That is fraudulent. So
But what do we have?
Sure. So if you look
There's a
at
duel of credibility here, and that's
Yep.
not for us to resolve. So could
Sure.
you help us out in that regard, please?
Sure. So if you look at, actually, the defendant submitted a supplement. That would be the transcript logs.
The findings on page 277 of the supplemental appendix, but I assume you're going to refer us to a different page or a different...
Yes. Yes, I will. Here, give me 1 second. I'm sorry. So a coworker by the name of Melissa Palermo and I were both added to WorkShare. And we both were removed from WorkShare because of our concerns for blanket reuse. The information in the transcripts will show that Melissa was also removed because of her discomfort with it.
You wanted to be removed though, right? Because initially they had added you, I thought inadvertently, but you requested to be removed from WorkShare, right?
That is true.
That was tied directly to the insurance benefits.
That is correct. And again, I told them that I would return. I was added to WorkShare, and then we had the conversation. I should say we had a conversation about WorkShare, and I told them that I was happy to return as long as they would not require me to reuse blankets. I was told at that time by the manager that I would be expected to follow the protocol as set out by Massage Envy Corporate. That was to reuse blankets secretly with my clients.
But ultimately, they opted, at least according to the hearing examiner, they opted not to. They opted to wash the blankets after every session.
That is what they said. So in the transcripts again, it will show Lauren Ben actually admitted that a number of employees had not returned. Her exact words
tell us
were,
that why?
Because of the not wanting to reuse blankets. I can say for sure that there was one employee for sure that I ran into later on. She expressed that because of what she was shown in the mock run on July 10th, she opted not to return. She was hoping that delaying her return would keep her from having to reuse the blankets. She herself said that when she returned, they were still reusing blankets, and that she was sure that she was going to catch COVID if she did anything in between that. So she actually expressed that herself. And again, Ben actually mentions a number of times here. She says, other employees have not returned. No return is not indicative of a quit, and that I was on a leave of absence like that of Palermo. So she had us pretty much aligned as far as our complaints were concerned about blanket reuse.
Okay.
Melissa would not return because of that safety issue, because she has a high-risk child, and so she opted not to return.
Okay. And did you opt not to return also?
Again, I told them that I would return as long as they could guarantee me that they would not make me reuse blankets.
So barring that guarantee, did you opt not to return?
I don't know how to answer that. They couldn't guarantee me, so I just stayed away. I did not quit. I made
What did
sure
you
that
do?
they knew
Did
that
you
I
opt
didn't.
not to return? You understand those words, opt not to return?
Yes.
Did
yes,
you do that?
I do. So, yes.
Okay, go ahead.
Okay? And that, again, that was because every time I spoke with them, I was being told that I would be, if I returned, I would be expected to adhere to the protocol document that they were keeping concealed.
Okay.
Okay?
Have you ever seen that document?
Yes, it is actually in my,
You have a copy of it? You submitted a copy of it?
sorry?
You submitted a copy of it?
Yes, I did.
Okay.
Yes, I did. It is actually, can I show you here? Page it is. In my appendix, it is a couple of places, but on page 21 through 22. It's actually an 8-page document. I uploaded just a couple of the pages because those pages actually outline exactly what was denied in that blanket reuse and how to go about doing that. It actually describes how to go about it. Ben and Quan denied that multiple times, as I list in my brief, roughly, pages 3 to 20. They denied this a number of times. They concealed it the entire time. And then, I should say accidentally, it seemed to me, uploaded it at the very end of our third hearing. And that is where my argument is. There was no way that I could read over it, ask questions, and do all that in the period of time that we were given there. The document was subpoenaed for the first hearing, which was in February. Ben opted not to upload that document, even though it was mentioned in the first hearing in February. She waited until the very end. Again, if you look through pages 3 to 20, she denied it, the owner denied it, and actually went as far as to say that I made it up. This was the same thing that they had told multiple state agencies, that I had made it up and that I was just a disgruntled employee. Actually, one of those state agencies, the Department of Labor Standards, sent out a representative to inspect and to request this document. They were told that it didn't exist. I later spoke with that individual's staff supervisor by email and by phone, and he verified that that document was not given to them. And that he actually says, I actually have a voice message. I'm happy to play it for you if you would like to hear it. He actually says, I am in receipt of the document. I have read the document, and it does verify what you have been saying all along. Again, these individuals concealed this. If they would have told the truth from the very beginning, it was first reported on July 27th to the Department of Unemployment Assistance Work Share Program. And it was, at that time, told to them that it didn't exist and that I had just been making it up.
But the hearing examiner cites to that document, right, at number 28 in her?
She does, because it was uploaded again at the very end, and that was only because at that point I had mentioned that I knew that the clinic was hiding or concealing the document from state agencies. She actually, Ben mentioned that, that I had been named by DLS, Department of Labor Standards, and OSHA in complaints. The hearings examiner pulled up information. A gentleman by the name of Adam Kinney from DLS had actually performed the inspection and was told that the document did not exist.
So this information was before the hearing examiner?
Yes. So again, the document was uploaded, but only because I kept saying, hey, I know that this exists, and finally.
And I saw you made this argument in the transcript. Okay.
Yes.
I want to go back to my earlier question about the hearing examiner's finding that the employer ultimately chose to change blankets after every session. I understand you dispute that. That's very clear. to what extent does your argument require us to find that that determination by the hearing examiner was error in order for you to prevail?
Sure. So if you look at the hearing notes, she reads, the hearings examiner reads text messages that I received from a coworker.
No, let me ask this question a little
Sure.
differently, because I understand what the argument is. The question is, my understanding of your argument is, if we agree with you and we determine that the hearing examiner made an error in that finding, you're saying you prevail. Is that correct?
So can you say that one more time?
Sure. I'm again referring to the finding that the employer chose to change blankets after every session. If we find that that is incorrect, are you saying that you prevail, that you win this appeal? Or is your argument, does it require more than that?
I would say that I would win if you would agree. I guess it would be, sent back to the lower court to be reviewed, that kind of thing? I don't know how everything works, everyone. I'm sorry.
No, that's okay. These are difficult questions. My follow-up is this. If we agree, I shouldn't say if we agree with the employer, with the finding, but if we determine that we cannot overrule that determination, does that mean you do not prevail on this appeal?
Yes, I guess if you agree with the examiner.
Okay. Let me see if there are any further questions. Justice Desmond, Justice Smith. Mr. Pitts, thank you very much for your presentation. And we will now hear from counsel for the appellee. How are you dividing your time?
Thank you.
Thank you, Mr. Pitts.
I'll be arguing.
Go ahead.
Yes, thank you.
You'll be making the sole presentation?
Yes.
And it's Attorney Lawrence? Thank you.
Yes, good morning. May it please the court. My name is Vanessa Lawrence, Assistant Attorney General for the appellee, Connie C. Carter, Director of the Department of Unemployment Assistance. This case concerns an appeal of a decision of the Board of Review of the Department of Unemployment Assistance denying Mr. Pitts unemployment benefits due to a lack of substantial and credible evidence demonstrating that Mr. Pitts had good cause for voluntarily leaving his employment. Mr. Pitts challenges the DUA's decision, noting the COVID-19 cleaning protocols put in place by corporate massage envy as good cause for leaving his employment. However, Mr. Pitts fails to meet the requirements of General Laws Chapter 151A, section 25E1.
Let me ask you this question. At some point during the hearing, did either the company deny this infectious protocol that he was referring to? Was that denied on the record, that it existed?
There was confusion as to what protocol was in question and whether or not Massage Envy had adopted it. However, in the April 9th, 2021 hearing in front of the DUA review examiner, Massage Envy uploaded the document themselves. The review examiner had an opportunity to review the document, allowed the parties to review the document. They asked clarifying questions, read certain parts into the record, and then allowed Mr. Pitts the opportunity to cross-examine Massage Envy employees regarding this particular document.
Okay. And so prior to April the 9th, you say there was some confusion. My question is more specific. Did they deny that it existed?
They denied that there was a Massage Envy Brookline protocol that allowed for the reusing of blankets. Mr. Pitts argues that there was concealment of evidence within the DUA review examiner hearing as well as at the BMC level, and as I've just mentioned, it was within the hearing transcripts, the discussion of this argument, of this protocol, and the BMC in affirming the agency's decision had access to the record as well as this discussion that happens in the transcripts before the DUA hearing, and therefore his claim, Section 47 claim, is without merit. In regards to Mr. Pitts' claim that he did not voluntarily leave his job, with good cause attributable to the employer. The BMC was correct in finding that Mr. Pitts voluntarily left his job. Specifically, Mr. Pitts was offered the same part-time job with the same pay rate as well as the same hours once the clinic reopened.
What about his safety concerns?
When Mr. Pitts initially signed his return to work form, I believe it was called the recall from furlough form, he indicated that he would be returning to work pending his safety concerns. As he noted, there are multiple conversations had between the employer and the employee. However, Mr. Pitts did not take further action in accordance with his intent to return. He did not fill out potential work schedule. He did not complete the required online training, nor did he attend the training in person on July 10th. Therefore, his grievances with the cleaning protocols were not informed by the trainings that the company had put forth for employees before returning to work. Additionally, he did not submit evidence that Massage Envy was in fact using this protocol, but rather, as the review examiner found in finding 28 and within the transcripts, the employer did consider the corporate protocol as a foundation in which they could then do more than that, and in doing so they did. They required that their particular branch of Massage Envy launder blankets and sheets between each client.
Let's assume that we cannot find that finding to be clearly erroneous. So in other words, that under our standard of review, we are compelled to agree with that. Is there any evidence in the record that Mr. Pitts knew that they were washing blankets ultimately after every session, that that is the path that they chose?
So under this statute, Mr. Pitts, as the employee, does have the burden to demonstrate that he left work voluntarily for good cause. In this particular instance, he did not present any evidence whether Massage Envy was laundering or was not laundering the blankets. Rather, he just demonstrated his overall disappointment and dissatisfaction with what he thought were the cleaning protocols in place. Massage Envy did, however, found within the record, have evidence that they were laundering the blankets in between each use. They had employees submit letters of their trainings, and there was testimony that although this was a corporate protocol, they adopted a higher, more stringent protocol for their particular location.
And prior to the hearing, was that information conveyed to Mr. Pitts, that they were going to adopt a more stringent protocol?
So within the record, I am not sure if that was conveyed to Mr. Pitts. What I can say is that the meetings that Mr. Pitts referred to prior to the reopening, there was discussion of what the safety protocols would be. Massage Envy did convey to its employees that they would be purchasing more smocks, more PPE equipment, things of that nature, and that the safety protocols that would be in place were still being developed. Had Mr. Pitts attended the in-person training on July 10th prior to the reopening, he would have been privy to what the protocols actually were in place.
So Mr. Pitts went out on furlough, correct?
Correct.
And after, did he ever return to the work site ever?
I'm sorry?
Did he ever return to the work site ever?
There were multiple text messages exchanged between the Massage Envy employer and Mr. Pitts throughout this process. As noted earlier, there was an issue with the work share program with which Mr. Pitts requested to be taken off of, and Massage Envy quickly corrected that mistake.
Did he ever return to the work site, is my question.
He did not, no. Additionally, Mr. Pitts failed to prove by substantial and credible evidence that there was good cause for leaving. As noted earlier, he did not submit any evidence that this particular protocol that he is disputing was dangerous or unsanitary. And in accordance with the Solar versus Director of the Division of Employment Securities case, Mr. Pitt's overall disappointment with the cleaning protocol does not rise to the level of good cause within the meaning of the statute, and therefore the BMC was correct in finding that Mr. Pitts failed to prove by credible and substantial evidence that he left for good cause attributable to the employer.
And the BMC judge also reviewed and had the benefit of the transcripts from the hearing, correct?
Yes, the BMC judge indicated that he or she reviewed the entire administrative record, including the transcripts, and therefore would be privy to the discussion of this protocol. Well, if there are no further questions from the court, thank you for your time, and I will rest on my brief.
Seeing none, thank you both for your helpful briefs and your helpful arguments, and the case is submitted. Thank you. Calling our next case, 22P214. I believe it's Zhao versus Quan. Please correct me on the pronunciation. We'll hear first from counsel for the appellant. I believe it's Attorney Riley. And am I pronouncing your client's name correctly?
Yes, Sophia Rong Zhao, client's name.
Thank you.
Good morning, Your Honors. So I represent plaintiff appellant Sophia Rong Zhao, wife in this divorce action. The issues in this court.
Before we get into the issues, may I just ask you a procedural question? It appears to me that, and you just told me how to pronounce your name, I apologize.
Oh, my name's Lei Riley.
And your client is?
Sophia, you can, maybe easier.
I hate to refer to her by her first name, but Sophia filed a motion to vacate the judgment after that judgment entered. Do you know what the status of that motion is?
No, I don't.
Has it been acted on at all, do you know?
I believe no action has been taken by the court on that motion.
Okay, so that begs two questions. So there could be no notice of appeal taken from that motion to vacate because it has not been acted on, correct? No, sorry. Only counsel may speak.
I'm not aware of any action taken on that. My client represented herself at the trial, so
Okay. Okay, you may continue your argument.
So in summary, there are three issues here at this court. Two of them related to the alimony order, and one related to the property division. For the alimony order, the issue at appeal is on the twofold. One is on the plaintiff's ability to pay the child support, which clearly indicated in the court's finding that she's unable to pay because her weekly expenses exceeded her weekly income in the judge's finding. On the second issue is on the defendant husband's need for support. that the error in that decision involved several aspects. Mainly is on the court decision that assigned a $15 minimum wage to him without any ground. And that number, if had increased by $4.30, would eliminate his needs based on the court's finding. And then secondly, the decision on his needing support is completely without any factual support or collaboration, and also was never raised, not in his counterclaim, and not raised in his status conference brief in November 2020, just a few months before the trial, and after the discovery has been closed. And considering that, the testimony without any collaboration, so that's the second issue. On the property division issue, the court has erred in properly applying the factors in determining the property division, and there's contradiction within judge's finding in
So
this.
You don't allege that there were factors that he didn't consider. You just say that he considered them wrongfully. Is that your position?
Yes, Your Honor. So judge did consider many factors, but without explanation. For example, when he did find the wife is a super contributor to the family enterprise, including a primary caretaker to their son throughout the marriage. However, then he said that it's equitable to assign significant equity to the husband without explanation. And then to further go down to the detail, the entirety of the division was on parties' two pieces of real estate. One is a primary home, the other is a three-family rental property in Dorchester, which was purchased just less than 6 months before the party living separately, and judge had found that on the day was May 5th, 2015. The property was purchased in November 2014, and it was damaged by fire substantially in March 2015, 2 months before husband moved out, and a total abdication of his family responsibility. Started paying in August 2018, more than 3 years after, $25 per week as a child support. So judge is finding that he has made no contribution. And
Was there evidence in the record that your client was receiving rental income from that Dorchester apartment?
yes,
And was
judge,
that factored also into the alimony calculation?
judge did factor that in, but even with that, if you do the math, Your Honor, judge found the annual rental income to be $8,333. So that added to wife's salary at $1,058 per week. Altogether, it's $1,218, still $20 less than the expenses of $1,238 that judge found and included in his finding. So, and the
How about the fact that the judge divided the estate 60-40? Can the judge factor that into the ultimate alimony calculation as well?
I don't believe judge did such, made no such connection. However,
My question is, could the judge have done so? Is that fair game?
I actually believe judge should have considered the property asset together with alimony, as the alimony and equitable division are interrelated remedies in our case law. The combination must make sense. This is by Casey versus Casey, 79, Mass Appeal Court, 623 at page 630 in 2011. And that's quoting Andrew versus Andrew, 27 Mass Appeal Court, 759 at page 761, 1989. And Gruber versus Gruber, 20 Mass Appeal Court, 811 at page 818, 1985. Quoting Gruber, well, equitable division may involve consideration other than those determinative of alimony. An order for division of property cannot be viewed apart from the alimony. If viewing the property division together with alimony, it's even unequitable, unjust to award alimony to husband, because in this kind of division, 60-40, wife would have to sell the property, and she will no longer have the rental income on his balance sheet. And this is another finding error at the trial court when the judge said a wife could refinance the property if she wants to. That has no factual basis. In fact, even by the defendant husband's statement, in his filed court brief, it's in the record, page 200. Defendant said husband had no significant involvement in repairing, improving the inside of the property. Oh, I'm sorry. It's record 165. The husband said, oh, no, that's...
I noticed in
it's basically husband said, neither party can refinance and buy out other party interest. It makes sense to sell both properties. So there's no factual support to conclude the wife at $55,000 per year annual salary can refinance the property. And even if she could, that would increase debt on her balance sheet. Her expenses will increase.
I noticed specifically that the judge discredited her testimony with regard to particularly with regard to her expenses. He said that they were overrated or overstated. And he also indicated several times that he didn't credit the marital debt that she alleged. He didn't credit the debt or liability of the wife. Findings 44 through 52 specifically pushed back on a number of those figures that were put forth by the wife.
Yes, you're right, Your Honor. And that number, so that's why he reduced her weekly expenses to $1,238 and did not consider that the loan statement and the debt he owed to the contractor who fixed the house after the fire damage in the rental property. That's why those issues are not being discussed here.
So you don't quarrel with those findings?
Well, it cannot be appealed at this point. So her debt amount to several $100,000 was not being considered. So we're talking about the street equity division in this two piece of real estate.
So you don't think it should have been 60-40, right?
I'm not arguing about it. I'm not arguing about a 60-40 division. The judge finding it because he had the discretion to make this ruling. However, there is a serious issue regarding the investment property, which was purchased just, I feel 60-40 division on the investment property is not consistent with his own finding, because the property was purchased less than 6 months before the husband's total abdication of his family responsibility. And just 2 months prior to that, the house caught fire. And this property was purchased in November 2014 for $510,000. That's all in the record. The down payment is $130,000. Mortgage was $380,000, which means the equity is $130,000 at the time. By the time of the judgment, the house was valued by the court of nearly $980,000. That is almost $645,000 increase of the equity. And that portion, by the court's finding, was completely due to wife's effort, the increase of the equity, which the judge's finding said if not for the super contribution of wife, the marital estate would be exponentially smaller. The judge also found that wife was the primary caretaker of the child and household throughout the marriage, except the 2 years when she was disabled. That was 2008. And also judge found in his finding 29, wife made significant homemaking contribution to the marital enterprise. Husband paid $25 per week, and that is more than 3 years after he just left the house. The marital enterprise and this family was solely supported by wife since May 2015. Based on this finding, the appreciation of the 51 Only Street, the three-family rental property in Dorchester, is not equitable to give 40% of that equity to husband.
So what should it be?
I think the court should find that look into the valuation date of this property. The case Daugherty versus Daugherty, in that case, 15 Mass Appeal Court 738 at page 741, 2001, the property valuation date is improper as the date of separation. Is improper as a judgment date because the date of separation is a proper time for identifying the marital property to be divided because the uncontroverted evidence at the trial indicates that the marital partnership effectively ended at the time. Similar to this case, and the husband had made no contribution since May 5, 2015, and that should be the date when the court decide on the property division. And in that case,
if that were the date and it's not 60-40, then what would it be? What would the division be?
if on that date at 60-40 and the party's equity in the rental property had only $130,000 case, so if the judge decided that's 60-40 based on that prior wife has been not only contributor to the finances working full-time, but also the primary caretaker of the child throughout the marriage. And she also was the one who was leading in finding the property and did everything from financing to mostly financing, and her husband just went there to sign the paper. So judge find wife was the leading cost to secure the property, and has been working full-time and being the primary caretaker for the child for the entire time. So if the judge decided 60-40, that the property evaluation date should be at the party's marital breakdown time, May 5, 2015. And similarly...
Your time has expired, but you can complete your thought.
So I just want to conclude. So wife has no ability to pay based on the judge's finding. Husband has no needs because he claimed he applied for Social Security disability, but it's in his own statement as well that he said it's unknown if he will receive or will not receive that benefit. So
Okay,
either he received...
I'm going to ask you one final question, and that's this. As I understand your first argument, you're saying that your client does not have the ability to pay because her expenses exceed her income. My question to you is a judge obligated to make the determination of alimony based upon income versus expenses, or her total assets versus expenses? Or is it a combination of all of those factors, not just a one-to-one?
Well, I do believe judge can consider all factors, but if he does consider that, he would find husband has no need, because if he's supposed to receive hundreds of thousands of dollars of asset distribution, he would have no need. In fact, without that, he would have no need either. If a judge had attributed $19 job that he could take instead of 15, he would have no need. He claimed he was applying for Social Security just before the trial. He either received the Social Security benefit, which he will have no needs, or he doesn't receive, means he's not disabled, he should be working.
I understand that part of your argument. I just want to make sure that you weren't arguing that a judge is obligated in determining alimony to strictly consider expenses versus income. There's a greater constellation of factors that a judge must consider, correct?
Yes, that's what I believe.
Okay. Seeing no further questions, thank you very much.
Thank you, Your Honor.
Attorney Kraft.
Good morning. May it please the court. My name is Bruce Kraft. I represent the defendant appellee. Bayong Chen is his last
Thank you.
pronunciation of his last name. Counsel has focused on essentially the two issues before this court. Number one, the alimony issue that was ordered after trial, and the division of the marital estate or marital assets.
Do you dispute her claim that the record reflects that her weekly expenses exceeded her weekly income?
I dispute it on the basis that, as I argued in the appellee's brief, in the husband's brief, when you calculate the various exchanges of money between the parties pursuant to the judgment, wife is actually getting additional money. She's not, her net
So that
payment.
really doesn't answer my question. My question is, do you dispute the claim that her weekly expenses, as that term is properly defined, exceed her weekly income? It's really a yes or no question.
Her weekly expenses as set forth on a financial statement, yes, the math adds up.
So you
But-
don't dispute that fact?
I'm not going to dispute that the math as set forth in her financial statement shows a negative.
So now I assume you're going to explain to us why, even assuming that fact is correct, that doesn't matter here.
I'm sorry?
I assume you're going to explain now how you can overcome that fact.
Yes, and I would suggest there are two factors to be considered. Number one, that there was rental income that was not appropriately reported on the financial statement in terms of the ability to pay alimony. But again, as I alluded to, Your Honor, I believe the more important point in determining the ability to pay is it's $127 that's going to come out of her pocket, out of her earnings, to pay to husband. But husband has to pay her I believe I calculated $172. So she's getting more money than she's paying out. So to argue that she doesn't have the ability to pay it doesn't seem to be a valid argument.
Some of those payments are more, that your client is making are more short-term than others, correct?
Well, they're child-related and insurance-related, yes. But the court is making its determination based on the evidence submitted at trial. If there is a change in circumstances thereafter, Massachusetts statutes clearly show that there's an ability to seek a modification if that payment was not sufficient. And again, some of the expenses listed on wife's financial statement are the total expenses. For example, there was a large health insurance payment of $189 a week, but husband was ordered to pay half of that. So that right away takes $94.50 away from her balance sheet, and she has more disposable money to pay the, I would suggest, very modest alimony payment. In terms of the other arguments that the wife makes as regards to rehabilitative alimony versus general term alimony, and the court considering the issues of husband's employability, again, I would suggest the record shows the trial judge considered those factors in making the determination. He considered the husband's ability to obtain employment in his chosen field, and he used the terminology rather dim. So it was a finding that husband did not have the ability to earn his full income, but he did attribute, the trial judge did attribute $450 a week in income, even though he wasn't earning it. And the trial judge also considered the husband's rather modest needs, and ultimately determined that with the $127, he would be able to enjoy the station in life that the parties had achieved at the time of the divorce. So
Let me ask you a different question. Are there any ongoing proceedings right now in the lower court with respect to this matter? No. What about the open motion to vacate the judgment?
the wife never pursued that.
Well, it was filed, it hasn't been acted upon, is my understanding
She
on the
hasn't-
record before us.
I apologize.
That's okay.
She never sought to have it heard. The court never scheduled it for hearing. She didn't seek to have it heard.
So what does that mean?
Well, it's a practical
Motion to-
sense for
there's a motion to
practicing.
vacate that's presently at the lower court, and it hasn't been acted on. So where does that leave us?
It's been waived.
According to you, says who?
It's been waived by the moving party because the moving party hasn't acted on it. Instead has proceeded with the appeal. I mean, as a practical matter,
But
again.
unless and until the judge acts on that motion, it is still pending. It is still an open motion before the court, correct?
There's been no docket entries, I agree, of course. There's been no docket entries, but the fact that we're here today, I would suggest constitutes, for all practical purposes, a waiver of that argument. I don't want to get into a discussion of the issues that sometimes take place in the lower court in having matters heard.
No, the reason we're asking is we need to contemplate whether or not it impacts what we do, because there is a pending open motion. It may be the case that it doesn't impact it at all, but we need to think through that.
Again, my argument on behalf of my client is the failure of the moving party to have the motion acted on constitutes a decision by her to waive that, and
That's
instead
possible.
proceeded with the appeal.
You have a case that supports that?
I'm sorry?
You have a case that supports that?
I cannot cite one. I apologize.
Well, at a minimum, there's been no notice of appeal filed from that motion in any case, so it's not before us.
That's correct. I would just then turn to the issue of the division of the marital assets. And again, Judge Dunn, who heard the trial, set forth in his findings of fact and rulings of law, detailed analysis of each and every factor required under Chapter 208, Section 34, in determining how to divide what he deemed to be the marital estate. He did not, and that is one quarrel that wife has, he did not exclude the investment property that was purchased in 2014 by both parties. Both parties applied, that was a finding, applied for a mortgage, obtained title in both names, had the responsibility for paying the mortgage, and there was, from wife's own admission, earnings that were achieved from this property that were not shared with husband in any fashion. And so although she did take the lead in the maintenance of the property and the management of the investment property, she did receive a benefit from it, and I would suggest that was certainly a consideration by the trial judge in determining how to divide that asset. I would suggest there would be no basis under Massachusetts law for excluding that property from a division of the marital estate. The wife proposed several theories during the course of the trial, that she had been the only one to contribute money towards the purchase. The judge did not find that to be credible. She claimed that she had borrowed money from family members, but could not substantiate that claim. So what we're left with is essentially the parties during the first 25 years of the marriage did have a marital partnership, as the judge found, and looked at it as both parties making equal contributions to the marital enterprise in terms of the family finances. The judge did find that wife had spent more time with the child-rearing aspects for their son, who both parties are quite proud of. In that regard, and in also taking into account that the judge made a finding that husband had, after May of 2015, when the parties separated, had stopped making his contribution towards the marital enterprise, if you will. He made a finding that the wife should receive a 60% share of the assets, which was a considerable sum of money, considering the value of the assets. And the judge made a specific finding that to the value of the assets, given the current or the market conditions at the time of the divorce trial. There was nothing improper in so doing, and so determining that the appropriate time to divide the asset is the time of the divorce trial, and not the time of the separation. And again, it gave the wife considerably greater share of the marital estate, considering those values. And the question of what should the judge have done instead of 60-40, I suggest is within the judge's discretion as the finder of fact and making his ruling. Should it have been 55-45? Should it have been 65-35? He made that determination. I would suggest it's not plainly wrong or clearly excessive, again, based on all of the findings that were made. I don't have anything further.
Thank you very much. We appreciate the helpful briefing and the excellent arguments in the cases submitted. Thank you.
Thank you.
Calling our final case on the list, 22P654, Pupolo versus Dinayatolis. And again, counsel can correct me on the pronunciation, please. Good morning, Attorney Hausler.
May it please the court, good morning. Douglas Hausler for the appellant. I believe this case is a rather interesting one for the court, and I say that not in any way to just curry favor, but there's a strong, I would even say argument, public policy issue here ultimately. Trial courts always encourage attorneys to try to settle cases as early as they can. And following that, what I'll call maxim or philosophy, that's what we tried to do in this case. And I'm saying it's no good deed goes unpunished, as we now have an appeal about whether or not there is, in fact, a complete binding settlement agreement. And in this particular instance, the facts and circumstances that the parties have found themselves when they were discussing the settlement are very material, I believe, to this court's decision-making or factoring into consideration. This case was not scheduled for trial. This case had barely had any discovery other than, I believe, exchange of documents. This was the first noticed deposition. It was between family members, one who's way out of state, Florida, acting on behalf of his elderly father, not with the decades of knowledge attributed to him by the trial court. So what we have is a party with extensive knowledge, the defendant, and a plaintiff who has some knowledge, no question, had inspected the property with the property manager, as the court found, the trial court.
3 months earlier, 90 days
3
earlier?
months earlier, 3 to 4 months earlier, yes, Your Honor. And that is important, I agree, but it doesn't address what happened here. So we don't even take the deposition because, in my experience of 35 plus years, once you take that deposition, all you've done is antagonize the other party. And we could always go back to the deposition if we are not successful. And instead, we worked cooperatively, I believe, with counsel. We arranged for time to try to get a settlement. We started, and we outlined lots of key points.
Who scheduled the deposition?
I did, Your Honor.
Okay.
And at the time, I'm sorry.
And you raised the settlement discussion prior to the depositions getting underway?
Your Honor, 2 weeks prior to the formal scheduling, I confirmed, and I believe it's part of the exhibits on the record of appeal, that we were confirming the date, and I had suggested a few days earlier to counsel, come earlier so that we could maybe perhaps get these parties who are related to each other to have some opportunity to discuss.
Good. And so that's what happened.
And that's what happened.
And then when it was entered on the record, that was at your behest?
And this is where I say that no good deed goes unpunished.
Dan, but that was at your behest, right?
I made the statement, with the deposition, the court reporter was present, and after we had discussed for about 45 minutes certain of the terms that we did put on the record. I am not disagreeing with what we put on the record, Your Honor.
Okay, one of the things you put on the record was going on the record to report a settlement in Suffolk Superior Court Civil Action Number 200547. What do those words mean?
To me, at that time, Your Honor, I was trying to give reference to the existing case because the court reporter was literally taking that down. I want to reference the parties and just reference the fact that we were getting to a settlement and that we had agreed on many points. I absolutely do not dispute the facts, what we agreed to that's on that record. I thought it was a great start. It was more than a great start. It was substantially moved ahead. But what's the most pressing piece of this puzzle is what took place not weeks later, but immediately after the court reporter left. That's what I've been trying to drive home in my pleadings, Your Honor, is we talked about things such as tenancies and security deposits and who's got a written lease or not. All that got on the record. When the court reporter leaves, we continue the discussion and we find out, oh, by the way, the occupancy permits for these two-family units are in question now by the building department of the city of Revere.
When
Well,
when was the next communication after the deposition?
Well, if you're referring literally that same day or after that discussion about the occupancy permits, Your Honor? Because that happened that
The next
day.
communication that was reduced to writing or memorialized in some way?
We received emails from counsel about moving forward with what was outlined in that record, and I did not reply because, for two reasons. My client raised, 'cause after hearing that there was a problem with the zoning, my client wanted to do what I consider due diligence, is the term I'd use, further investigation about that issue because it was material to him about what he would be encountering if he, in fact, went forward with the buyout. And if my client had determined that it wasn't going to be as big an issue as we thought, there was a way to go forward with what we had on the record. But my client learned otherwise and learned in his, I'll say, due diligence post, it was going to be a problem, a substantial problem, because it takes three different properties going, the income stream is dramatically affected, and more importantly, Your Honors, it's the ability to even do the repairs that both parties knew there were repairs that had to be done. But the extent of the repairs wasn't as clearly made known to my client as the trial court might attribute. But nonetheless, if you don't have the permitting to allow the two-family use, that is a material term. And I proved the fact that it's a material term because counsel, both of us, after the record was completed, quote unquote, discussed this for several minutes, not just a passing of the hand.
All right, that begs two questions for me. The first, let's go back to Judge Desmond's initial question, which is, if you had said on the record, rather than reporting a settlement agreement in docket XYZ, if you had said, reporting a proposed settlement agreement contingent on the agreement to essential terms to be memorialized in writing within the next 30 days, and then go through the terms, would we be here today?
Probably,
Why?
because I think the trial court inferred that what wasn't on that record could be inferred by it based on the record it had before.
What if you had used the terms I just said, contingent on, conditioned upon, agreement reduced to writing?
It would give me a much stronger argument, Your Honor.
Let me ask you this question. Because I agree with you, there are many policy reasons that cut in your favor. But let's drill down on the law first. The case law seems to use the terms essential and material interchangeably. I wonder if that's a flaw in our law or if the words are interchangeable, because it seems to me that in order for this to be a contract, the essential terms must be agreed upon. But it would also seem to me to be the case that certain material terms could be omitted, and you could still have an enforceable contract. It strikes me those are two very different words with very different meaning, but our case law uses them interchangeably. Could you help me out in that analysis?
Not any better than you just did, Your Honor, because I do think that's a discrepancy within the principles that are applicable in this particular matter. It's a very good point, Your Honor. I saw the fact of the zoning as I would say, as an essential piece, because the underlying structure of what was discussed on the record was predicated with the presumption by all, at that moment when it was being dictated by me, that these were legal two-family properties. I think that's absolutely an essential argument factor to be included in an overall settlement. It's more than material. It's essential, because without operating as two families, the complete intent of the parties to settle on the terms they did it vanishes because it's not affordable.
Let me make this more difficult for you hypothetically.
You're doing a great job, Judge.
Let's assume, well, thank you. I'm having a good day. Let's assume for the sake of argument that truly hypothetically, we haven't reached any conclusions. Let's assume that we think that those missing terms are material, but we don't think they're essential. What then?
It's going to make me consider whether I want to have further appellate review is one. I don't say that frivolously, Your Honor. I think it's a very good point you're raising. I don't have a quick answer for that, Your Honor. Respectfully, I don't. I see the assent. If you say it's, I have a hard time saying it's not even material, I guess, here. It was material enough.
No, my question is, let's assume that the omitted terms,
That's right.
we say, yes, we agree, they're material, but we don't think they're essential.
I think that would be counterproductive to the overall goal of the settlement. I think that you're required, in this context, in the context that we're dealing with, Your Honor, particularly, if we were in a mediation with a formal mediator, going back and forth, defining terms, just like you've proposed here, having, numerous notations made back and forth, negotiating almost a purchase and sale agreement, I could follow that a lot easier. In this, under the facts and circumstances of this case, we really we didn't take advantage of that opportunity. We didn't do that. We worked very diligently in trying to get to an agreement without getting into the nuance of essential versus material. I think it's a great point, and it was one that we did not address. And in retrospect, I've learned more in this particular matter than I care to imagine after 35 years of practice. What I do know is a client of mine is going to have forfeited his right to a trial in his day in court because counsel worked diligently with their clients to get to a settlement before even a deposition. And there is no prejudice here to the defendant.
It sounds like buyer's remorse.
It isn't, Your Honor.
That's what it sounds like.
And I would respectfully disagree for the following reasons. It's not buyer's remorse. If buyer's remorse is, I just don't want to go forward, that's one thing. It was, my client's reaction wasn't knee-jerk to say, that deal's off 2 days later. My client went through the process of doing, I'll consider due diligence, about an issue that was raised immediately after the dictation.
I understand the timing, but let me ask you this. So you have this conversation right after the recording was made.
Yes, Your Honor.
And when you left the room, what was your understanding then?
What was my understanding?
What was your understanding with the other side? What did you guys believe?
We're going to further investigate because counsel had been kind enough to suggest that he's a more local attorney in that area, that he had relationships with the building department because they're just familiar with each other. Nothing inappropriate, please. Yeah. Absolutely not. He provided some guidance about what could...
Did you memorialize that in a letter the following day or a week later?
No, Your Honor, we did not because it wasn't determined...
I've been doing this for 35 years, right?
Yes, Your Honor.
So why not? If your understanding is, listen, reasonable minds can differ as to what went on the tape, but we've come up with these other material, essential facts that we were discussing that we really weren't able to agree on. You just leave that out there?
I leave it out there because we were going to be drafting documents and addressing issues such as we had agreed on the terms of the financing. We hadn't formally agreed on the extent and scope of the security, but I don't want to get into that one case because there's Fiamara that I think is direct, or 9 acres, I think it is, excuse me. 9 acres is exactly on that point about the form of security was not deemed to be a material issue enough that something the court could fill in the gap. That wasn't what I was dealing with here. I'm dealing here with a client that we were advised immediately after the record was completed, before any report of a settlement, before depositions taken, everything else not done. We're going to document it, we're going to explore it, and the fact that we made the good faith effort to try to settle this without all those things gets completely cast aside by strict enforcement. And the trial court made several leaps here, Your Honors, that if I could point out quickly, one of which, because I'm very limited on time, one of which was the court said, well, I disagree with the plaintiff about the need to have an evidentiary hearing on those topics. The topic that is at issue here is primarily the zoning and permitting and the allowed use. That isn't even in the record of the four corners of the dictated statement. So I don't know how the judge could just, Judge Wilson's brilliant, but he just quickly cast over that and said, well, I don't think it's material or essential, perhaps, to use the court's words. I find that to be somewhat inappropriate, and that's why we reverse it.
Your time is up, but I actually want to follow up with another question. I want to make sure that our understanding is correct.
Yes, Your Honor.
You're alleging that there were three missing terms from the contract, three either essential or material terms. Is my understanding. One is the condition of the properties. Two are zoning and permitting issues, which I think we can combine those actually into due diligence.
Yes, sir.
Correct?
Yes, Your Honor.
And the other one is the consequences of non-payment of the initial $100,000, correct?
Yes, Your Honor.
Is that the universe of missing material or essential?
Yes, Your Honor.
Wonderful. Anything further? Seeing nothing further. No,
I do a follow-up.
Judge Smith.
My question is about extrinsic evidence. Do you believe it was error for Judge Wilson to rely on extrinsic evidence in inferring parties' intent?
I absolutely do, yes, Your Honor.
And you've referred to extrinsic evidence, so haven't you?
Because the court did.
So your position, the Superior Court judge was limited by the transcript,
No, Your Honor. I'm
by the
sorry.
affidavits as well.
By the affidavits before it, Your Honor.
So he properly considered the affidavits.
It appears that he did, but inferred certain things from those affidavits that are not supported by any part of the record.
I expect we'll hear from counsel that your interpretation, though, of zoning permit occupancy permitting issues were not new to your client.
The occupancy was new, that's the point. Not the condition of the properties as much. If I may, I want to be careful over time here, Your Honor, but the condition of the property is significantly impacted by the zoning, as that's why I think they have to be considered together. If you're not allowed to operate the properties as two families, you by nature can't make some of these repairs. And they're completely upside down on the financials for a deal to be made here. And that's exactly why I thought that the trial court made an error where it said the status of the occupancy permits is not a material term of the transaction, which was on page 5 of the trial court's memo. I think that's an error of law. It's absolutely not only material, it's essential. And the court never even gave us the opportunity to have an evidentiary hearing on that particular point, which might have saved us a lot of time and effort and this court. Thank you, Your Honors.
Thank you.
Appreciate your time.
Well argued. We will now hear from counsel for the appellee, Attorney Turco. We recognize Attorney Curhan as well.
Thank you, Your Honors, and may it please the Court, Attorney Jeffrey Rosario Turco for the appellee, with me on the brief, Attorney Dana Allen Curhan. If I could, Your Honors, get to the last couple of questions you had about material versus essential, I'd refer, Your Honor, to the Duff case. And in the Duff case, they talked about the parties had come to an agreement on the settlement amount of the money, but they never agreed on what date the money was due. And what the court in that case said was, hey, look, all contracts have a duty of good faith and fair dealing. So once we conclude the essential terms, how much you're going to pay is involved, then the court can fill in the blank with when the money is actually going to be due by using a reasonableness standard. So to the extent that my brother tries to muddy the waters about whether it's material, whether it's essential, the essential terms are here. They're not my words, they're his words. He suggested...
Do you see a distinction between essential terms and material terms?
I don't think so in the context of this case. I think it's sort of an overcomplication of the straightforward issue that's before the court.
Because Duff doesn't distinguish between those terms. And I don't think either of the parties in your briefing distinguishes, and I understand that because the case law, again, in my view, and I could be incorrect, seems to jumble the two.
Yep.
But my concern going forward is that I believe there is a distinction between terms that are essential to the contract, without which you cannot have a binding meeting of the minds, and material terms, which are often subject to subsequent negotiation even after a contract has been formed but not finalized. Again, I may be wrong, but that's where I'm struggling, just so you know.
And I would think, Your Honor, with respect, to the extent that Your Honor points out that neither one of us addressed that issue, I think the argument is my brother waived that argument, and we're left with the argument before the court is this essential? What I think is he's made a lot of hay about after the settlement. The question is, were all the essential terms present at the time he dictated the settlement, and was there a meeting of the minds at that moment? It can't seriously be disputed. Two seasoned counsels, not 35 years, but 25 years, sitting across from my brother, with both of our clients present after 45 minutes of discussion, back and forth, shuttling between offices, come to an agreement. My brother goes on the record, and as Justice Desmond says, I'm reporting this case settled. But not only does he say that, Your Honors, he goes forward and he says, payment shall be remitted on or within 30 days. The parties have also agreed to stipulate the case will be dismissed with prejudice. We talk about the land court case that's going to be dismissed with prejudice once everything's carried out here. We talk about how the security deposits are going to be accounted for. We talk about the August 1st rents and how they're going to be accounted for. We talk about my client making 2 payments within 7 days of the meeting to my brother. Now, my brother doesn't, says, well, there was no agreement, but we sent him the 2 payments. The record is clear that we sent him the 2 payments. He didn't negotiate them, but he didn't send them back saying, why are you sending these to me? We don't have an agreement. And the court can find that in the appendix about the payments.
Well,
At page 139, lines 8 through 18, where it talks about we sent him the payments in accordance with the settlement, and he never sent them back saying we don't have an agreement.
The specificity of the terms at the deposition inures to your client's benefit. What of the language, though, that almost sounds conditional, such as, it will be agreed as follows? At times used, or your brother used the term, we have agreed, but then there's terms like it will be agreed as follows. The parties are also going to agree that. There's some language in there that one could argue sound like an agreement to have an agreement.
Well, I think, Your Honor, the parties can reach an agreement. The case law is clear that we could reach an agreement and then agree that we're going to document it over later on. And essentially what we did here, and the record shows this, is we came to an agreement. That agreement was final and binding, that we both agreed that we had vacations planned, because it's the month of July and August. We both had a vacations planned, and that's referenced in the again, in the appendix, where we talk about our vacations at appendix page 58 and page 141, lines 11 through 13, and page 143, lines 16 through 17, where we say, hey, we're on vacation. That's why we set it up for 30 days. But when you look at what it says is, defendant shall write a check for $3,223 on or within 7 days. Defendant shall send half of the $20,734.78 on or within 7 days.
All of this is in the context of the opening, which says it will be agreed as follows.
Which is the line that comes after we're reporting the case settled, Your Honor. He doesn't use a...
My concern is that an agreement to agree, it's black letter law that is not a contract. In this case, arguably falls somewhere in between, but go ahead.
Well, I think when counsel starts out by dictating, quote, I'm reporting this case settled and states the docket, when he says we're going to dismiss this case with prejudice and we're going to waive all rights appeal, Your Honor, I'm not quite sure how, it's sort of like, Congress shall make no law. I don't know if it needs to, maybe you could make it firmer by saying Congress shall make absolutely, positively no law. At some point, you take it to an absurdity level. And I think when counsel starts off, again, his suggestion, let's document this. I'm reporting this case settled, his words. Now, I think what's important, too, is...
Was it reported to the court as settled?
No, it wasn't reported to the court as settled because it was all going to be done within a 30-day period to do this. And what I think it was Justice Smith asked the question about, Justice Desmond asked the question about, did you document any of this? Now picture this. We're sitting in a room. We have a court reporter take down a settlement. My brother would have you believe that after the court reporter left, suddenly the whole deal effectively blows up over a discussion in his office. No paperwork, no communication. We send him the 2 checks in accordance with the settlement agreement. He doesn't send them back saying, why are you sending them to me? We don't have an agreement. I don't know why you sent these to me. He kept the checks. He didn't negotiate them, but he kept the checks. Then I send him an email on August 11th, appendix page 58. The email says, I called you a couple of days early. This was on a Wednesday. No response. Send him an email August 20th. Where are the documents? Appendix page 60. Send him a letter via email August 24th.
Let me ask you a question about the letter. In your letter on August 24th, you write, per our agreement, you were to send along proposed draft documents for review and approval by my client.
Yes.
How are we to interpret draft documents, review, approval?
Because, Your Honor, what we agreed to at the settlement conference was that, or at the deposition that became a settlement conference, was we were going to have a mortgage, we were going to have assignment of rents and leases, there's going to be a promissory note. So obviously, he was setting up his LLC, he was sending over the draft documents for me to make sure that they're obviously, they're sort of customary and consistent, commercially reasonable. If, in this case law that talks about this, some of the cases in our brief we talk about, there's a lease case where, I think it was SMS, where, it escaped SMS though, where they come forward, they had a 15-year track record of leases, and then when they tried to come up and they gave a lease that was completely different than the previous 15 years, and the court said, no, you can't do that. The parties can reasonably rely on what they were talking about. So we go in and we agree this, what the term of the mortgage is. We're going to take back paper. There's going to be assignment of rents and leases, and my client's completely secure. My brother again says, well, what happens if we don't, we didn't specifically say what happens if he doesn't pay the $100,000? There's a breach of contract action, Your Honors. I mean, it's pretty simple. You don't have to list in a contract, here's every parade of horribles that can happen if he acts as a bad actor. He enters the agreement. He's going to pay the $100,000 within 30 days, and then he says, well, what if I decide to breach that and not pay it? You didn't list what the penalty was for that, and therefore, I'm not going to be bound to the agreement. I think that's the doctrine of unclean hands, that he can't come in here and make that argument to the court and then try to rely on his own bad conduct. But the other part of this, I think, Your Honor, is, he talks about the occupancy permit and the smoke detectors, he talks about the condition, and I think it's critical. It's simply not true, and the record proves it, that he knew about the occupancy permit issue in advance of the negotiations. I refer Your Honors to appendix page 127 with exhibits regarding those. It's an affidavit of me with discussions with my brother's predecessor counsel, where I specifically talk about we need to put the smoke detectors in so the city will issue the occupancy permits. He knew it. They talk about, he says, I'll talk to my client about this. So
there's also communication about perhaps a property is not properly zoned or permitted for two-family. Is that correct?
That's the occupancy issue, Your Honor.
Occupancy, correct.
So essentially, at the risk of going a little far afield, essentially the city's position is once you get the smoke detectors in, we'll give you two-family occupancy permits. That was it. So there is no zoning issue. You do the smoke detectors, you get your occupancy permit. They refused to let us do they refused to consent to us installing the hardwired smokes, which led to the city holding off and issuing them. But to say that he walked into that negotiation not knowing just is not correct. I mean, it's, again, I refer you to appendix page 127 with the exhibits, with the emails, unrefuted in the evidence before the judge below. And I know we're here de novo, but the other part of it is he talks about, well, he was surprised by the condition. As Your Honor, Justice Nyman said, 3-4 months earlier, he personally inspected the property. He writes an email, which is in page 99 of the appendix, where he says to me, because he fired his old counsel, he hadn't yet hired my brother, and he says, there's huge liability. This place is in deplorable condition. The risk is huge. I'm slightly exaggerating, but not that slight, that much. But attached to his email are documents from the management company. And what I say to you is page 36 and 37, appendix page 83, exhibits 1 through 4 and 6, In Exhibit 6, he talks about the hot water tank needs to be replaced. That's at page 103. The heating systems need to be replaced in 106 and 110. The roof needs to be replaced at 107. So to say that he was suddenly shocked and appalled at the condition of the property when he himself had the documents in his possession and provided them to me. I didn't have them. He gave them to me. And now he tells the court, well, I didn't know how bad it was.
So before the stenographer, when your brother was reading the terms of the settlement, being an experienced attorney, knowing there were issues out there, some issues with occupancy or that hadn't been resolved, it didn't occur to you, or it wouldn't have been wise practice to say, when there's anything else, well, there's other issues, but we've agreed, et cetera?
I mean, I guess in hindsight, we probably could have done that, Your Honor, but I think frankly, it's such a slam dunk issue with the city. Put the smoke detectors in, you get your occupancy permit, so it's sort of a non-issue.
So you saw it as a non-issue?
Oh, I saw it as a non-issue, and that's why it wasn't raised. And I think my email says that I referred to earlier, where I told them, to Attorney George Heiler at the time, another seasoned counsel, where I said, look, all we got to do is put these in and we get our occupancy permits. I mean, it's pretty simple, black and white. And they chose not to approve us because this is tenants in common relationship. We couldn't spend money to do it without his approval. And they refused to give us approval. And now he comes here as sort of the guy that killed his parents and says, please, I have no parents, have sympathy for me. He created the situation.
Let me ask you this question.
Yes.
Mr. Hausler starts out the deposition transcript by stating, going on the record to report a settlement in Suffolk Superior Court Civil Action number 2547.
Yes.
What if he said instead, going on the record to report a settlement framework in Civil Action 0547, and to be clear, the settlement is contingent on the parties agreeing in writing to all terms of the contract, something to that effect.
We're not here, Your Honor. I don't win in the Superior Court, Your Honor, if that's the case. But I think what was so clear to the Superior Court, and what I suggest to you, to this court, is his words matter. He starts out by saying, I know there's that one sentence about, well, the second sentence in the settlement agreement, but he starts out by saying, I'm reporting this case settled. And again, we go through every minutia of a detail. In fact, the Superior Court judge below commented when I said, Judge, we even agreed on how to divide up the security deposits. And he said, where is that, counsel? And so I go through the transcript and I show him. He goes, okay. I mean, he talks about that and he says, look, he waived the due diligence period. He's a serious, seasoned counsel. He never asked as part of his rendition, hey, I want to preserve a due diligence period. I reserve my client's rights. We have a separate lawsuit between my client, the uncle, and his client, the nephew, in another Superior Court action unrelated to these properties, and I specifically reserved that. I said, we're going to keep that case alive. If we had intended not to make this binding final settlement, I wouldn't have had to go and make that point that not only am I preserving my right to keep that case here in the Commonwealth, but I may actually have to bring it in Florida as well. And so when you look at all of these and the totality of the circumstances, the question is, 4 people in the room with the court reporter, sitting across the room, would they really walk out of there believing that they didn't have a final binding settlement? And if something suddenly happened 10, 15, 20 minutes later in Attorney Hausler's office, why wasn't it documented over? Why was the first piece of paper from Attorney Hausler, I disparagingly call it, not to my brother, but it's a hostage letter. I'm relaying to what my client has authorized me. And then the letter goes through and...
Your time has expired.
Thank you, Your Honor.
Let me ask you one more question. Is the Duff case your best case, or your most favorable case to you or your client?
I mean, we cite a bunch of cases on, the Targus case, I think really just lays out the black letter law in this area. So I think Targus is probably on point. I think Duff I really was citing for both propositions that support my case, but also to respond to Your Honor's question about material and...
Just check to see if the panel has anything further.
Why were there no depositions taken?
I have no idea why they didn't. We didn't feel the need to do a deposition. This case went on for a year and a half, and then there was about a year before they filed suit that we were exchanging documents and going on the docket sheets in this record that shows. So this wasn't a case that was filed and 2 weeks later we had a settlement discussion. It was a year and a half. We produced 10 years worth of receipts and records as part of voluntary discovery to Attorney Heiler's office. 10 years of every single paper receipt dealt with the property. We produced it. So it wasn't like nothing had happened in this case. You know, they then at some point, they served written discovery. We responded to written discovery. Then they finally said, we want to do a deposition. We said, fine, do your deposition. We didn't feel the need to.
Judge Smith has a question for you.
I think perhaps plaintiff's strongest case is Rosenfield. Are you familiar with Rosenfield from 1932? It was negotiations over a storefront. If you're not, that's fine.
Yes, no, I have a case.
Yes. How do you distinguish, because the language there is also pretty literal. We have an agreement, we have a settlement, but there was ongoing issues about, for instance, the storefront, utilities. How do you distinguish our facts from that case?
Yeah, I mean, Frank, I looked at it last night, and I should have brushed up a little bit more, Your Honor. But, I mean, my recollection of that case is that they talked about the essential terms of what the lease would be, but they left open, hey, that we got to talk about what this, you know, what's going to happen with the storefront. And ultimately, that became, the court found, hey, it's a big deal, the storefront, because I think it was, the numbers they were throwing around at the time we laugh at today was, I think, $5,100 or something was the number it was going to cost to do the storefront. But in the 30s, that was a lot of money. And so I think the court looked at that and said, you know, as a condition of renting the property, you're requiring the tenant to spend this substantial sum of money at that time to renovate a storefront, the final details of which they were going back and forth, saying, well, let's split the cost, or we'll be responsible for, I think, the first $1,000. And if I'm misstating that a little bit, I apologize, but that's roughly the range that I recall. And I think that's the difference here. There was none of that here. And that, again, came all after the settlement. Everything my brother has alleged came before. I apologize, Your Honor.
No need to apologize. Thank you both. Excellent arguments, excellent briefs. I'll state for the panel that both of your clients received excellent representation on this case. So the case is submitted, and that concludes our session for today.
Thank you very much, Your Honors.
All rise, please. What is the recess? Can I have the case for number 3?
So now I
Basically,
get out.
yeah, you can basically